Hello friends, in the series on the income tax cases, today we will discuss a case in which the issue before the Honorable Jharkhand High Court was that whether it is the obligation of the legal heirs of a deceased assessee to inform immediately to the revenue about the death of the assessee or surrender his PAN number after his death, or in other words, if the assessment order is passed in the name of a deceased assessee, by having the knowledge of the death of the assessee, then in that case whether that assessment order has any sanctity in the eyes of the law. This issue has been very well taken up by Honorable Jharkhand High Court in the case of Sujata Devi versus Income Tax Officer, and this case is reported in 472 ITR at page number 463. The date of the judgment is 15th February 2024. The facts of the present case are like this. In the present case, the death of the assessee happened on 14th February 2015. After the death of the assessee, after 6 years, on 30th March 2021, a notice was issued to the assessee, and that notice was hanging at income tax portal. After that, the wife of the deceased assessee received the notice under section 142 subsection 1. The wife of the deceased assessee wrote at the back of that envelope, which is being received by the speed post in the form of a notice, that the addressee has died and it has been received by his legal heir. This much of the information was given to the revenue by the wife of the deceased assessee. After that, when the assessee received the notice from the verification unit, in response to that notice also, the wife of the assessee brought to the knowledge of the National Faceless Assessment Center that the assessee has died, and she also submitted the copy of the death certificate of the assessee. But in spite of this information, the revenue went ahead with passing the assessment orders, and the assessment orders were passed on 13th March 2022 under section 147 read with section 144 read with section 144B, and a demand of rupees 24,72,813 was created, and even the penalty orders were passed. The wife of the assessee filed the writ petition in the Jharkhand High Court by challenging these assessment orders and penalty orders for the request of quashing them, because on the plea that these has been passed in the name of a deceased assessee. When this matter was heard by the court said that according to section 159 of the Income Tax Act, which talks about legal representative, the revenue cannot pass the assessment orders in the name of the deceased assessee without bringing on record the legal representatives of the assessee. The court also said that if the department is not intimated about the death of the assessee, then it does not give right to the revenue to extend the period of limitation. And in the present case, since against the notices issued, the revenue was well in the knowledge that now the assessee is no more, then in that case, by very much relying on the Supreme Court judgment in the case of Principal Commissioner of Income Tax versus Maruti Suzuki India Limited, which is reported in 416 ITR at page number 613, it is a settled law that any assessment done in the name of a non-existent entity has no value, and it is devoid of merits, and it is liable to be quashed. So in the present case, there was no denying the fact, there was no doubt that the revenue was in the knowledge that the assessee is no more. So having that knowledge, if the assessment order is passed, then that assessment order do not have any sanctity in the eyes of the law, and the court quashed all the assessment proceedings and all the penalty orders. At the end of this video, once again, I am repeating the name of the case. The name of the case is Sujata Devi versus Income Tax Officer, and this case is reported in 472 ITR at page number 463, and the date of the judgment is 15th February 2024.